To start the show off on the right foot for 2015, we shall begin with business and immigration law updates. This is a presentation of the Khurana Law Firm, where the Chief Principal Attorney is Attorney Ramesh Khurana. He joins us today with moderator Kenneth Haber, also an attorney in Maryland. Today, the moderator, Attorney Kenneth Haber, will question Attorney Khurana on concurrent filing of immigration petition and adjustment of status. Let's join these two gentlemen in their discussion.
Good morning and Happy New Year. This is the Capitol Forum. I'm Kenneth Haber, a former Assistant United States Attorney and former Senior Attorney in the Office of Inspector General of HHS. With me today is Ramesh Khurana. Ramesh, welcome.
Thank you.
Happy New Year.
Happy New Year to you and Happy New Year to the audience as well.
Ramesh is a very well-known immigration attorney who services people from across the world and across this country. Ramesh, are you ready to answer some questions?
Sure, always ready.
Very good. Can you tell us what's meant by a current filing of an immigration petition and an adjustment of status?
Sure, Ken, I'll be very happy to do that. So the question is, what is the concurrent filing? Concurrent filing means filing simultaneously two types of different petitions. So when we are talking about concurrent filing in regard to the adjustment of status, so that could be combined with the immigrant petition, which is I-140. So I-140 is the petition which is filed by the employer, and when the priority date is current, then you can combine immigrant petition with the adjustment of status package. When we are saying the adjustment of status package, there would be three different types of applications. One would be I-485 and second would be I-765, which is the employment authorization application, and third is the advance parole application, which is I-131. So you are filing four petitions at the same time because the priority date is current. And likewise, in a situation where a foreign national marries a U.S. citizen and U.S. citizen is filing a petition for the foreign national who is in United States, in that kind of situation also concurrent filing is permitted because priority date is always current for the U.S. citizens' spouses. So you are filing I-130 and the adjustment of status package.
How does that work out if a person wants to take advantage of the I-485 and the I-140 in terms of their spouse and children?
You know, the way it works is once you have filed a petition, usually the receipt notices for receipt of applications and the fee payable to the USCIS, these come to the attorney's office and the applicants within 2 weeks. And the next stage is there is a request coming to the beneficiary or the foreign spouse for the fingerprint notice. They give you about 3 to 4 weeks. So the person has to go to the application support center of the USCIS to give the fingerprints, and that is for the purpose of checking the background. And then there is always an interview when the green card application is based on the marriage, because so many frauds take place and people have abused the system. There is a mandatory interview. It's never waived when a petition is filed by the U.S. citizen spouse for the foreign national based on marriage. So interview usually comes because USCIS district offices are moving very fast, especially I have seen in Maryland, DC and Virginia. Usually within 4 months, the applications are adjudicated and foreign nationals receive their green cards and they are on board.
Very good. What's the meaning of advance parole and employment authorization?
Sure. Again, as I said, as part of the adjustment of status package, you are including these two applications. One is the employment authorization. Now, employment authorization application is filed on Form I-765. What does it mean? If there is a delay in grant of the green card petition, the person has to work. Now, it is well recognized that a person who is here, that person should be given an eligibility and an opportunity to find work and support himself or herself. So, that is why EAD application usually is approved in 90 days after it is received by USCIS. Now, second application is Advance Parole application. Now, this is of utmost significance in the process. This application comes very handy and comes to the rescue of the foreign national if foreign national has to travel overseas in an emergency. Otherwise, if you are not carrying your advance parole with you, then your application for adjustment of status is deemed abandoned. So, that means you cannot pursue this application. So, that is why we always advise our clients that even if you have to travel overseas, you have to wait for the approval of the advance parole. And as I said, usually green card applications are being adjudicated in about 4 months. Our always advice to the people is don't leave until you get your green card. Get your green card and then you leave for your home country.
Very good. If a person files for the I-140, can they still seek adjustment?
Yes. So, that means the person chose to file I-140 in the first instance and did not opt the concurrent filing. So, when the I-140 has been filed and if it is not yet approved, you have the receipt notice for filing of I-140. So, based on the receipt notice, you can file the adjustment of status package. And if the I-140 or immigrant petition is already approved and the priority date is current, then you file the adjustment of status package.
Wow. You know, these processes really get complicated.
Yes, these are little bit complicated, but once you start immigration practice and you do it over and over, experience teaches you well. This is what I have learned in my practice.
Right, right.
Just by reading books, you really don't learn.
No,
You have to do it practically.
What's the H-1B status?
You know, H-1B status is derived based on a special petition which is filed by the employer. This is the employer petition, and there are some special requisites who are eligible to be covered under the H-1B petition. Like it says specialty occupation, person must be holding a bachelor or equivalent of education and work experience, and the employer has to pay wages which are usually payable to the US citizens or green card holders, so that there is no abuse of H-1B system. Then H-1B can be given only for a maximum period of 6 years, unless there are some additional circumstances which would provide the benefit of extending H-1B petition beyond 6 years.
If a person's in H-1B status, can they file for I-485 and I-140?
Yes, a person who is on H-1B status, he can file I-140 when the labor certification process is approved, which is called the PERM application. Once the PERM application is approved, then you are filing I-140 or immigrant petition, and then depending upon the priority date, if the priority date is current, then you can move on to the adjustment of status package, and the adjustment of status package would again comprise I-485, I-131 and I-765. So, this package, whole package can be filed along with the fee, which at this point is $1,070.
That offsets, I'm sure, just a little portion of the cost that the government is bearing.
You know, now the policy of USCIS has changed. They say that for the purpose of immigration benefits, they should be fully compensated. This is what the indications are.
That's what they're trying for?
Yes.
If a person's applying for a work permit, but he changes his job, should he apply for a new H-1B?
If a person changes his job, the question is, of course, he can move based on the employment authorization document which has been issued to him as a result of adjustment of status package, but we always recommend that if you are holding an H-1B status, please continue to keep it until the adjudication of your green card or I-485 petition. The reason is you never know. So something wrong may happen to your adjustment of status petition, maybe I-140, there were certain serious irregularities, not because of you, but because of the employer. Some frauds were there, misrepresentations were there, and employer comes into trouble, I-140 is revoked. All of a sudden you find yourself that you do not have any legal status in this country. So that way, if the green card process is abandoned because of unforeseen situations, when you have an H-1B, you can restart the green card process with a different employer. So we always advise, keep your H-1B alive.
If a person has both the 140 and the 485, and the 140 is denied like you're talking about, what would happen to them then?
You know, let me say this person is out of luck. If I-140 is denied, and if you have filed the adjustment of status package because of the concurrent filing facility, then this is the underlying petition. This is the foundation for the adjustment of status package. When the foundation is no more, the whole structure which has been created over this foundation vanishes overnight. So your whole green card process stands terminated if the I-140 is denied. So you have to restart the process.
Oh, that's rather draconian.
Yeah, and you know, again, if I-140 denied, sometimes you may think that you have a solid ground to file an appeal. So again, you have to talk to your competent immigration lawyer who can evaluate your situation and decide whether it's worthwhile filing an appeal, because sometimes wrong decisions are made by USCIS. Absolutely.
What happens to your status during the appeal?
Depending upon, as I said, we always advise people to keep their H-1B alive. So if people are keeping their H-1B, so they are in valid status, undoubtedly. So that's the reason. When you asked me this question, I said our advisory to all the persons is, even though your green card process is at an advanced stage, you are expecting adjudication within 4 weeks, 6 weeks, and your H-1B has fallen due, take advantage of your H-1B and keep it renewed, keep it valid.
And that's not a difficult task, I take it.
You know, again, depending upon the situation of the employer and the employee, but hopefully everything is in place, there should not be any issue.
Do you have any final words for the viewing audience concerning the topics that we've just been touching upon?
Yeah, concerning the topic, my advice is that concurrent filing of I-140 or I-130, if you are being sponsored by your spouse, along with the adjustment of status package, is a great facility. Take advantage of that so that your green card process gets completed in the shortest possible time, which I guess is between 4 to 6 months. But for the family based, at this point it's about 4 months. Take advantage of this process. At the same time, if you are on H-1B status, keep your H-1B status alive. So that if something wrong happens, things go sour, you do not go out of status. H-1B will help you in that kind of situation. Thank you very much for being with us. Don't forget to talk to your competent lawyer if you really have some immigration issues. This is a complex world. And again, I wish you a very happy New Year.
Happy New Year.
Thank you.
Thank you.